Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, contracts core doctrine, formation, terms, and defenses. Let's begin. Core contracts questions test whether the parties created an enforceable obligation and, if so, what obligation they created. The exam rarely announces the issue. Instead, it gives messy communications, shifting forms, oral promises, later modifications, and a party trying to escape. Use this sequence: governing law, offer, termination, acceptance, consideration or substitute, statute of frauds, terms, defenses. Do not jump to breach before proving the contract and its content. Offer. An offer requires objective manifestation of present intent to contract, definite and certain terms, and communication to the offeree. Objective theory controls. Secret intent is irrelevant. Termination by lapse. An offer terminates at the time stated or after a reasonable time. Face-to-face conversations usually lapse when the conversation ends unless circumstances indicate otherwise. Termination by revocation. An offeror may revoke before acceptance unless the offer is irrevocable. Revocation is effective upon receipt. Revocation may be direct or indirect if the offeree learns from a reliable source that the offeror took action inconsistent with the offer. Irrevocable offers. An option supported by consideration is irrevocable during the option period. A UCC merchant firm offer is irrevocable without consideration if signed and assuring it will be held open for up to 3 months. Beginning performance of a unilateral contract creates an option to complete performance. Detrimental reliance may make an offer temporarily irrevocable when reliance was reasonably foreseeable. Termination by rejection or counteroffer. A rejection terminates the offer when received. At common law, a counteroffer is both rejection and new offer. A mere inquiry does not terminate the original offer. Bilateral contracts. Acceptance may be by promise or beginning performance, depending on the offer. Unless the offer specifies otherwise, acceptance may be made by any reasonable method. Unilateral contracts. A unilateral contract is accepted by full performance. Once the offeree begins invited performance, the offer becomes irrevocable for a reasonable time to complete, but the offeree is not bound to finish unless performance is completed. Mailbox rule. An acceptance sent by an authorized medium is effective on dispatch unless the offer provides otherwise, an option contract is involved, or the offeree first sends a rejection and then an acceptance. If a rejection is sent first and acceptance second, whichever arrives first controls. Silence. Silence is generally not acceptance. Exceptions arise when the offeree takes benefits with reason to no compensation is expected, prior dealings make silence acceptance, or the offeree intends silence as acceptance. Consideration. Consideration requires a bargain for exchange. A promise to do what one is already legally obligated to do is not consideration at common law. A promise not to sue on a claim can be consideration if the claim is valid or the claimant has a good faith belief in its possible validity. Pre-existing duty. At common law, modifying a contract usually requires new consideration. Under the UCC, a good faith modification of a goods contract needs no consideration. Promissory estoppel. A promise is enforceable if the promisor should reasonably expect reliance. Reliance occurs, and enforcement is necessary to avoid injustice. The remedy may be limited as justice requires. Restitution. A person who confers a benefit may recover to prevent unjust enrichment when the benefit was not officiously conferred and the recipient had reason to know payment was expected. A later promise to pay for a material benefit previously received may be enforceable in some modern cases, but not for gifts. Covered contracts. The statute of frauds generally covers marriage promises, contracts not performable within 1 year, land contracts, executor promises to answer personally for estate debts, goods priced at $500 or more, and suretyship promises. Writing. The writing must identify the parties, indicate a contract, and contain essential terms. For UCC goods, quantity is the key term and enforcement is limited to the quantity stated. UCC exceptions. Goods contracts may be enforceable without a sufficient writing for specially manufactured goods, admissions in court, payment or delivery accepted to that extent, or between merchants when a confirmatory memo is sent and not objected to within 10 days. Common law exceptions. Land contracts may be enforced with part performance, usually possession plus payment or improvements. One-year contracts are enforceable if fully performed by one side. Promissory estoppel may overcome the statute in some jurisdictions when reliance is strong. Integration. The parol evidence rule applies when parties reduce an agreement to a final writing. A complete integration is final and exclusive. A partial integration is final, but not exclusive. Effect. Prior or contemporaneous evidence cannot contradict an integrated writing. Consistent additional terms may supplement a partial integration, but not a complete integration. Admissible evidence. Parol evidence may be admitted to show formation defects, defenses, conditions precedent, interpretation of ambiguous terms, course of performance, course of dealing, usage of trade, or subsequent modifications. Hierarchy under UCC. Express terms control course of performance, which controls course of dealing, which controls usage of trade when they cannot reasonably be reconciled. Mistake. Mutual mistake makes a contract voidable if both parties were mistaken about a basic assumption. The mistake materially affects the exchange, and the adversely affected party did not bear the risk. Unilateral mistake usually requires knowledge by the other party, fault, or unconscionability. Misrepresentation. A fraudulent or material misrepresentation inducing assent makes the contract voidable if reliance was justified. Non-disclosure can count when a party has a duty to disclose. Duress. An improper threat leaving no reasonable alternative makes a contract voidable. Physical compulsion makes it void. Economic pressure alone is not enough unless wrongful. Unconscionability. Courts examine unfair surprise, oppression, one-sided terms, and unequal bargaining. The doctrine is flexible and often appears with arbitration clauses, disclaimers, or consumer contracts. Illegality. A contract with illegal subject matter is usually unenforceable. If only part is illegal, a court may sever the offending term if the rest is lawful and consistent with policy. California generally follows modern contract principles, but may emphasize unconscionability, public policy, and the implied covenant of good faith and fair dealing. For bar essays, California may use both common law and UCC analysis. For MBE, apply the majority rule unless a statute is specified. A counteroffer kills the original offer. A question does not. Beginning unilateral contract performance creates an option, but not a completed contract until performance is done. UCC modifications need good faith, not consideration. Parol evidence does not bar evidence of fraud, duress, mistake, or later modification. The statute of frauds is a defense to enforcement, not proof that no agreement existed. Expect communication chains, email offer, voicemail revocation, mailed acceptance, purchase order form, oral modification. Put events in order and use effective upon receipt versus effective upon dispatch rules carefully. Then ask whether a writing or defense changes enforceability. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.